I agree with why the wineries wanted to be separated out, but again, it goes to my original point that we have two distinct differences here with the permanent facilities and temporary facilities. And maybe this temporary event has been abused with the reoccurring quantities and 60 of them in a year or something like that. But as Mr. Greening said, you know, temporary does mean reoccurring, you know. So I just feel that we're getting out in front of this thing with the board, and I know we're supposed to take an action here. So again, you know, I would prefer to continue on as is until the board gives us a different direction.
I guess I just hope we could move back, because I think we've kind of segued into the question of whether there needs to be a separate MUP for each event.
That's the last thing.
And that was the last thing on our list.
Yeah.
So I think we need to move back, because we need to stay on move on to the definitional question of secondary and incidental.
Yes,
since we've decided that is relevant. So if we could move back there.
The MUP is the last thing to talk about. So, what does secondary and incidental mean? We have two competing interpretations.
Well, that's what we've asked the board to tell us.
We've asked, the board has given a directive to amend the existing ordinance to make it easier and more streamlined to get these permits. But before we can determine how we make it easier, we have to determine what is the baseline. What is it now?
Well, my understanding that is somewhere we're planning, and the Ag Department do agree, because we heard testimony here in the previous hearings that the Ag Department does agree that secondary and incidental does not mean that it has to be related to. And I think that's in Mr. Eisen's current letter that we have here we've been referring to. So I don't think there's a whole lot of disagreement on that issue inside the departments. There may be some up here on the panel and out in the public, but I don't think there's much disagreement there amongst the...
Well, I'll speak up next. Actually, in this case, I do agree with Mr. White and with staff and in the Ag Department and in planning. I don't necessarily think that's the direction that that it should go in the sense of the future changes, but I think that is what has been traditionally and historically how it's been interpreted. And looking at the AG, the Ag Policy 6 myself, that's really how I looked at it. I mean, to me, secondary and incidental are ways of describing, you know, casual, minor, less than. I certainly do not think that incidental means anything less than 50%. There's another little thing that made my eyebrows go up. But it does, to me, in this situation, I know that the Ag Tourism Council would like to argue for the interpretation of related to, and again, that may be an important and good way to go, but I just couldn't figure out a way to get to it through our current ordinances and regulations, and I didn't really understand how the accessory use definition and the home occupation stuff figured in. And so, if I'm going to change my mind on that one, someone's going to have to figure out how to do it logically. Because, yeah, I'm with the Ag and Planning and Mr. White on this one.
Mr. Wyatt?
Yeah, I have a hard time with the terminology. I didn't pick up several dictionaries, and you did?
I did.
Okay, I know several people out there did. Yeah, I think the intent is for it to be limiting there with the sort of definition of incidental, you know, as related to, and I don't know what the intent was or how the definition matters. I think the point of pulling in the home occupations and the other accessory use were to try to make some kind of relevant comparisons or find meanings there. And no, I didn't find any kind of consistent run-on logic there that we could pull from. So I would have to say that, as far as I know, it's kind of the broader use of incidental, not necessarily being related to, but being minor. So back to what you said, it's that question of just what minor is, whether it's 5% of the land area or 10 or something. So I think that's what we need to hash out, but not necessarily strictly related to the agriculture.
Gentlemen?
I don't know how you're going to measure it. I mean, I don't want to do it financially. That won't work. I think we have to depend on the ag department.
Well, we're dealing with land use, so I think the ag department's got it right. We're dealing with it with size and scale. We're not the IRS, so we're not going to deal with it with monetary values. We deal with land use, and that's the way the ag commissioner's office is interpreting it now, and I think that's the correct way to do it.
Yeah.
But I guess, yeah, the question is, so again, that question you're answering then about incidental, what qualifies as incidental then, if not exactly related to agriculture? You're moving on to kind of answer that question.
Yes, secondary and incidental is on, secondary and incidental in my mind does not have to be related to the agricultural use, but to be secondary and incidental, it's on size and scale of the operation. So.
As the agricultural department kind of defines.
I agree with their interpretations.
Well, here's where my former editor takes over, my inner editor. And I look at secondary and incidental as two different words. If it just meant secondary, it would have just said secondary. And if incidental means the same as secondary and doesn't mean related to, then there's no point in having the word in the ordinance. It would just say it has to be secondary to the ag
Commissioner
use.
Christie, if you did not go to law school, you would know that there is a way to say everything, at least 45 different ways, and they all mean the same thing.
But I don't think the people who crafted this policy went to law school either. I think they were just general citizens like us, and they had something in mind. And I think what they had in mind, when you read this policy in the context of all of the ag policies that are clearly meant to protect and preserve and promote long-term viable commercial agriculture in the county, that the reason those words secondary and incidental were chosen was because there's an acknowledgement that additional non-ag uses on ag land are a good thing, and they're an important thing, and they're actually a beneficial thing to the long-term productivity of ag land if they are associated with agriculture in some way. I mean, because if they're not associated with agriculture in some way, then you could make the argument for a small, less than 5% secondary, less size-wise, used car sales lot on your ag land.
I got 4-0 on this one. 4-1.
No. You said you were open to
I'm not buying it.
You said you were open to having your mind changed.
I've just told you.
I'm having that discussion now.
I'm trying to move it right along.
I'm trying to have a deep policy discussion and have us all remain open-minded.
I think your approach is laudable, and I'm drawn to it, but I do not think that that's where we've been in this county. I do not think that that's the interpretation that we are getting from either ag or staff. I think it's maybe a desired interpretation for the future. It's certainly a desired interpretation by our requesters, but I just don't see it there.